and I will be your bailiff for this arbitration session. I'd like to begin by extending our gratitude to our esteemed panel of arbitrators and our finalist teams for agreeing to this arbitration today. May I take the pleasure in introducing the tribunal comprising of Dr. Asanga Gunavansa, President's Counsel, Dr. Kananayagam Kanagiswaran, President's Counsel, Justice Arjuna Obesekara, Mr. Amrit Rajapaksha, and the presiding arbitrator, Justice Janaka De Silva. Dr. Gunavansa is a President's Counsel with a practice of over 27 years in commercial law, investment law, project financing, construction law, and environmental law. He is currently the lead counsel at Colombo Law Alliance, a leading chamber specializing in commercial law, construction law, and arbitration. Dr. Kanagiswaran is a President's Counsel and is a leading Sri Lankan lawyer. He was called to the bar at Lincoln's Inn in 1964 and called to the bar in Sri Lanka in 1966. He practices in the original courts and appellate courts of Sri Lanka. He specializes in aviation, banking, and finance, corporate, commercial, intellectual property, insurance, shipping, and telecommunication. Dr. Kanagiswaran is a lecturer at the Faculty of Law, University of Colombo, and a visiting lecturer at Sri Lanka Law College. His Lordship, Justice Obesekara, is a judge in the Supreme Court of Sri Lanka. He joined the Attorney General's Department as a state counsel in 1993 and then went on to become Senior Deputy Solicitor General. He was appointed to the Court of Appeal in 2018 and went on to become its president in 2020. He was appointed to the Supreme Court in 2021. Justice Obesekara is an expert in commercial litigation, having worked on several banking and arbitration matters during his time as a counsel. Mr. Rajapaksha is an attorney at law with a legal practice spanning over 20 years in the areas of civil and commercial litigation and intellectual property law. He currently practices as a counsel in the original and appellate courts of Sri Lanka. Mr. Rajapaksha also practices as an arbitrator in commercial and construction disputes and is a member of the SIAC panel of arbitrators and the WIPO Arbitration and Mediation Center's list of arbitrators. And finally, His Lordship Justice De Silva is a distinguished Supreme Court judge and has served as Senior Deputy Solicitor General and played pivotal roles in major litigations. Recently, he was inducted into the Seychelles Court of Appeal and elected as an honorary bencher of Gray's Inn, London. His Lordship also imparts legal knowledge at leading institutions in Sri Lanka. Before we begin, I'd kindly request all participants to please pay attention to a few guidelines for this arbitration session. The total time for this session is 90 minutes. The first 10 minutes of the 90-minute session will be allocated for the teams to discuss the order of issue, order of proceedings, and the time to be allocated for each speaker. At the end of the discussion, the parties are kindly requested to communicate to the tribunal on how the time has been allocated amongst the two speakers. This is for both submissions and rebuttals. Following the submissions of the first speaker from both teams, there will be a round of rebuttals. Similarly, after the second speaker from both teams have concluded their submissions, another round of rebuttals will take place. I will indicate the time left by lifting firstly the 5 minutes left board and then 2 minutes left board. And once the time allocated has concluded, the time's up board will be lifted. The arbitrators may ask questions during the oral hearings the way they would in a real-life arbitration, taking into account that this is indeed an educational exercise. Researchers are allowed to assist the speakers by passing notes or chits. However, researchers, please note, you are not allowed to verbally communicate to the speakers. No exhibits may be used during the oral arguments that do not come directly from the problem. Exhibits that are designed to clarify time sequences or other such matters may be used, but only if the arbitrators and the opposing teams are in agreement. Thank you very much, participants. Now your 10 minutes to decide on the procedural order for this arbitration session shall begin. Again, a kind reminder, please ensure to inform the tribunal on the order of issue and proceeding and the time allocation for each speaker. Thank you. Your time starts now. Okay. What's your time allocations? Your speaker one. Mm-hmm. Mm-hmm. Mm-hmm.
Followed by Respondent for issue 1.
Mm-hmm.
It will be 6 minutes.
Mm-hmm.
I will be spending, for me, I'll be doing issue 5 for 3 minutes.
Okay. So, speaker one, yes?
And speaker 2.
Speaker two. Okay, so speaker two, what are the issues you're taking?
I'm taking
Speaker 2 will
So
be taking issues 3, 4, and 5.
Mm-hmm.
But because the first issue and the fifth issue is spoken on
No, I
first,
just need your
just like the overall.
yeah, just need your
altogether.
timings. That's it.
Okay.
oh,
Because I
okay,
can then.
sure.
15
Yeah.
minutes.
So you're speaker one,
And
yes?
speaker 2 for.
Can I have speaker one, please?
I am speaker 1, and I'll be dealing with issues 1 and 2. For
Mhm. Thank you, teams. I will now be handing the session over to the panel of arbitrators, and I will start the timer when the first speaker begins his or her speech.
Respected members, may I proceed? Good afternoon, respected members of this tribunal. I am Deepali, Team Code 1, and together with my colleague, Mr. Vedant, we represent the respondent state of Equiterra in the matter before this tribunal today. The matter we are faced with today is unique, learned arbitrators. Equiterra finds itself unexpectedly pitted against the pharmaceutical giant Pharmanex in a complex legal battle, one wherein it must defend its right to prioritize public health over corporate interests while the well-being of millions hangs in balance. Over the course of the next 12 minutes, I will present two broad submissions. Firstly, that this tribunal has no jurisdiction over the current dispute, and second, that the statute of the host state can override a bilateral investment treaty. Before we begin with our first submission, would this tribunal prefer a brief summary of the factual matrix? Sure, thank you. Coming to issue 1, our first submission pertains to the tribunal lacking jurisdiction over the current dispute, and the same is submitted on 3 grounds. Firstly, that the dispute resolution clause does not apply to the investment agreement. Second, that the claimant has not fulfilled mandatory pre-arbitral requirements. And third, that the claimant's actions invoke the principle of investor illegality, thereby precluding this tribunal's jurisdiction. Beginning with my submission on my first prong, if I could guide the tribunal to page 8 of the facts on record, the notice of arbitration. If the tribunal is with me, clause 3 states very clearly that the arbitral agreement that has been invoked is based on the investment agreement. Now, if I may guide you to page 18 of the investment agreement, clause 6 is a mere reference to the bilateral investment treaty, while clause 2 of the investment agreement clearly states compliance with local laws of Equiterra. Therefore, in the lack of an arbitral clause in the investment agreement, we claim that local courts of Equiterra are best equipped to deal with this issue at hand. Further, regarding the claim of the bilateral treaty being imported into the investment agreement, we claim that there is no consent to arbitrate in the current matter. Clearly, in clause 6 of the investment agreement, it stated that the bilateral treaty will be read in only where necessary. And in this case, the local courts are very clearly equipped under clause 2, and there is no express consent to transfer the arbitral agreement, which is the cornerstone of arbitration. With this, I end the submission on my first prong. If this tribunal has no further questions, may I move on to my second prong?
Does not the inclusion of the bit of the incorporation into investment indicate some consent?
Thank you for your question, Mr. Arbitrator. There is no consent indicated over here. It's clearly stated that only where necessary, the framework of the bilateral treaty shall be included in the agreement. But here clearly that there is no express consent that is given. And that's the hallmark of what is required when you're transferring arbitration agreements, which wasn't met in this case. Thank you. If I may proceed to my second prong.
One point on your illegality submission. Is it a matter that can be taken up at the outset, or is it a matter that can be decided after hearing the parties on the merits?
Sorry, Mr. Arbitrator, I couldn't hear you completely.
Sorry, the question of investor illegality. Is it a matter that can be raised as a preliminary objection on jurisdiction, or is it a matter that will have to be considered after the merits?
Thank you for your question, Mr. Arbitrator. We do claim that it can be dealt as a jurisdictional issue, but if the tribunal is not satisfied with the same, the tribunal is sitting here to discuss all 5 matters on the agenda, and we claim that the tribunal must keep the principle of investor illegality in mind while determining the question of admissibility of the current issue. Thank you. Moving to my second prong, wherein the prerequisites for the commencement of arbitration as per Article 4 of the BIT has not been met. If I may take you to the bilateral investment treaty at page 14. If the tribunal is with me, Article 4 of mentioning the dispute resolution mechanism clearly states that if the dispute cannot be settled amicably within a reasonable period, the investor may submit the dispute for arbitration. Over here, if you notice the word cannot be settled amicably within a reasonable period, the shall before this makes it mandatory for the parties to commence amicable resolutions before approaching the tribunal, which wasn't done in the instant case. Further, they haven't met the reasonable period requirement. Negotiations before commencing arbitral proceedings only went on for a month, and this is not sufficient in any regard. The standard for negotiations to take place is 6 months, and this is supported by the tribunals in Occidental, Murphy, and numerous other treaties across the globe. Here, the 6-month period wasn't met, and this is relevant because of the circumstances in which we've come to the arbitral proceedings. There's tensions in Equiterra regarding the healthcare supply. It's very clear that our intention is not to disrupt the healthcare chain. Hence, it's our intention to first ensure that negotiations take place and there's an amicable resolution of disputes. And over here, due to the gravity of situations, it was necessary to have a longer period. Hence, the claimant has not fulfilled the pre-arbitral requirements. Moving to my third prong, which was investor illegalities principle. As mentioned by Mr. Arbitrator, the claim is of jurisdiction, but we understand if the same has to be considered on its merits, can be continued upon the point of admissibility. And for the same, I submit that the claimant has violated the host state's laws in the form of the Health Equity Act's Section 3 and Section 4 by failing to meet the supply quotas and further by setting higher prices for medicines in the rural areas. With this, I come to the end of my first submission, and in conclusion, we respectfully request this Honorable Tribunal to hold that it lacks jurisdiction to decide upon the current dispute. With this Tribunal's permission, may I move on to Equiterra's second broad submission on issue 5.
For you,
Yes,
if I
Mr.
can draw your
Arbitrator.
attention to clause 4, which you referred to earlier at page 14.
Yes.
You highlighted the word shall, but also it says, if you look at the third line, if possible, be resolved through amicable settlement. So isn't it very subjective? I mean, who is going to decide whether amicable settlement is possible or not?
Thank you, Mr. Arbitrator. Again, in this situation, I would like to read out from ambient officios' decision based on their bilateral treaty itself. Clearly, they state, shall be insofar as possible resolved through amicable consultations. In the Tribunal's opinion, the language of the provision clearly suggests that it creates a mandatory duty for the parties to enter into consultations. So we submit that regardless of the word if possible, the mandatory pre-arbitral requirements have to be met in the current situation. Thank you. If I may proceed to my second submission. Thank you. My second submission is in regards to the host state's laws prevailing over the bilateral treaty. And the same is submitted on 2 independent grounds. First, that the Health Equity Act overrides the bilateral treaty, and second, that the respondent did not breach the general exceptions clause in the form of Article 5 of the bilateral treaty. Moving on to my first prong, there is no conflict between the Health Equity Act and the bilateral treaty. International investment law favors mandatory application of host state law. The only time it doesn't apply is when there's a conflict between international law and the host state's laws. But clearly, according to Clause 2 of the investment agreement and Clause 5, host state laws are designated as applicable rules. And hence, since there is no conflict between the regulations, according to the principle of party autonomy, the intention and the choice of the party shall be taken into account, and therefore the host state law will override the bilateral treaty. Proceeding to my second prong, that the respondent did not breach the general exceptions clause in the form of Article 5. The general exceptions clause indicate that the host state's laws will prevail over the bilateral treaty. And the same comes with conditions as mentioned on page 14 of the bilateral treaty. If the tribunal may look at Article 5, investors and their investments shall comply with the laws and regulations of the host state. Nothing in this treaty shall be construed to prevent the host state from adopting or enforcing measures necessary for the protection of public health, which was met in this case. This shows the intention of the parties to adopt laws that are inconsistent and so override the bilateral treaty. Further, the same is not arbitrary or unjustifiable and will be dealt with us in submission 2 and submission 4. But for a brief factual thing, it's not arbitrary or unjustifiably discriminatory because the claimants are not in the same position as other investors or local companies in Equiterra. So their differential treatment is justified by the state of Equiterra. With this, I come to the end of my submissions. Equiterra was suddenly thrust into legal battle over issues that preclude this tribunal's jurisdiction. With the lives of millions hanging in balance, we respectfully request this tribunal to recognize the lack of jurisdiction over the current dispute. Thank you.
Members of the tribunal, before I begin, can I check if I'm audible? May it please the tribunal. I'm Kevin Ting, and I, along with my co-counsel Benedict Woon, appear on behalf of the claimant Pharmanex. I'll address the tribunal on issues 1 and 2, while my co-counsel will address issues 3, 4, and 5. Members of the tribunal, the claimant, being dedicated to public health, has invested much of its resources into producing state-of-the-art medicines and has tried its level best to keep prices affordable. But the HEA has dictated its business, threatened the viability of its investments, and is now being used to justify its nationalization. At this juncture, the claimant has no choice but to bring this claim before the present tribunal. To that extent, I'll be making one submission on the jurisdiction of this tribunal. We submit that this tribunal has the requisite jurisdiction to overhear this dispute because the arbitration agreement in the BIT has been effectively incorporated into the investment agreement between the claimant and the respondent, and that the preconditions of amicable settlement have been satisfied here. Members of the tribunal, consent is the cornerstone of the jurisdiction of any tribunal, as held in the 1997 case of American Manufacturing and Trading and the Republic of Zaire. Therefore, it is necessary to establish both the consent of the state and the investor before the tribunal has jurisdiction. However, there is no need for specific consent to be present within the investment agreement itself to establish the consent of both the state and the investor. This is because by agreeing to arbitrate under the BIT, the state of Equiterra has already consented to the jurisdiction of this tribunal. In other words, it is a unilateral offer to arbitrate, accepted when the claimant submits its request of arbitration. And in the present case, the claimant would have submitted its request of arbitration through its notice of arbitration, which can be found at page 7 of the bundle itself. Therefore, given that the consent to arbitrate under UN CITRA rules is complete in this present case, we submit that the arbitration agreement in the BIT has been effectively incorporated into the investment agreement itself, and that this tribunal would have the jurisdiction to hear this present dispute. Further, the preconditions of amicable settlement would be satisfied here. Referring to page 14 of the bundle, under Article 4 of the BIT, it states that an investor may submit a dispute for arbitration if the dispute cannot be settled amicably within a reasonable period. It is clear here that the amicable settlement is not a necessary condition due to the words, if possible. We submit that the precondition of no amicable settlement within a reasonable period will be satisfied here. This is because a reasonable period would have two requirements. First, that genuine attempts at negotiation and consultations be made, and second, that further attempts at negotiations be futile. In the present case, it is clear that genuine attempts at negotiations and consultations have been made. Page 5 at paragraph 19 states that the impasse continued to persist even after attempts to resolve the dispute through diplomatic channels and negotiations. Further, it appears that further attempts to negotiate would be futile. This is because the respondent is set on nationalizing the claimant in order to enforce the HEA itself. And this can be seen at paragraph 18 at page 5 of the bundle. As such, given that the two criteria are satisfied, we submit that the reasonable period of time would be satisfied here, and the preconditions of amicable settlements would be met. As an additional point, the respondent raised up the defense of illegality. However, we note that illegality will not serve as a jurisdictional bar in this case because the investment itself was not illegal from the very outset. It was held in the case of Bank Mali and Bahrain that illegality will only be a jurisdictional bar if the investment was illegal from the outset due to some illegal purpose or due to the fact that the investment was made through some illegal means. However, in the present case, it is evident that the investment by Pharmanex was not illegal at all. I refer the tribunal to page 18 under Recital 1, which states very clearly that Pharmanex investment was for the collaboration on healthcare initiatives and investment opportunities. Nothing on the facts states that the initial investment into Equiterra itself was illegal. Therefore, illegality will not serve as a jurisdictional bar in this case. Unless I may be of further assistance to this tribunal, this concludes my submission on the first issue. Thank you.
Okay, Counsel, I have a question for you. The issue of amicable settlement that which you made submissions on, you said that an adequate attempt has been made at amicably resolving the issue, but you also said it appears on the part of the respondent that they were adamant to proceed with the nationalization, and that highlights that there is no room for amicable settlement. But isn't it the position that nationalization itself by a state or expropriation is not illegal, provided that there is timely and adequate compensation? And if so, the negotiation should be on the issue of compensation. So to that effect, is 1 month sufficient to conclude negotiations successfully on the issue of compensation?
Mr. Arbitrator, my co-counsel will address the merits of the nationalization later on. However, it is not our position that nationalization itself is illegal. Rather, what we submit is that the respondent is already set on nationalizing the claimant itself. And as a result of this, it is, apologies here. It is because the respondent is set on nationalizing the claimant himself, which is why further attempts at negotiations will be futile, because it is unlikely that they will agree to any compensation or with regards to attempts to resolve this dispute through other means aside from nationalization itself. Therefore, we submit that further attempts at negotiations would be futile here, and therefore the requirement of no amicable settlement within a reasonable period of time will be satisfied here. Unless I may be of further assistance to this tribunal, this concludes my submission.
Before I begin, could I check if I'm audible? Thank you, members of the tribunal. May it please the tribunal, my name is Benedict Woon, and I'm co-counsel for the claimant, Pharmanex Inc. With the tribunal's permission, I'll be taking 3 minutes for my submission on issue 5, whether the HEA can override the BIT. And on this, we submit that the HEA cannot override the BIT because the BIT specifically provides for subsequent measures like the HEA. If I may refer the tribunal to page 14 at Article 5, it states that subsequent public health measures like the HEA should not be applied unless they are on a non-discriminatory or on a non-discriminatory or a non-arbitrary basis. And on this, we submit that the whole point of overriding the BIT is on the assumption that it, in the first place, conflicts with the BIT. And so if there's no conflict, as the respondent submits, then this issue is not relevant. But on the plain language of the BIT, an arbitrary and a discriminatory measure would not be able to override the BIT. And as we will submit in the later submissions, the application of the HEA is both arbitrary and discriminatory to the claimant. and as such, the HEA cannot override the BIT. And to the extent that the respondent is justifying the HEA through their sovereignty, we submit that while it is recognized that the respondent has the sovereignty to pass legislation, it is not an unfettered one, and it is precisely Article 5 of the BIT which governs the respondent's ability to pass public health measures, and as such, the HEA cannot override the BIT. Unless the tribunal has any further questions, this concludes my... Oh, Mr. President, yes.
Is it your position that as long as the domestic law is not arbitrary or unjustifiable, it can over-trump the BIT? At the moment it is established that it is arbitrary and unjustifiable, then it cannot.
Yes, that is exactly our position, Mr. President. Thank you. And if there are no further questions, I conclude my submissions for issue 5 here. Thank you.
Mission. May I begin my rebuttal? Due to the paucity of time, I'll be countering merely 3 arguments made by the claimant. Firstly, regarding how the dispute resolution clause is present in the bilateral treaty, but they haven't answered how exactly it transfers to the investment agreement when the arbitral agreement they have invoked according to UNICITRAL rules is the investment agreement. And here, clearly under clause 2, it's already mentioned that the local law shall be abided by, and hence there is no reason to look at the bilateral treaty. Further, on the second submission of reasonable duration, they haven't again mentioned why the period of 1 month is enough. Given the circumstances of merely 15 days after the SC directive asking for immediate measures, they presume futility of our negotiations. However, 15 days is not enough considering the gravity of the situation as mentioned. Thank you, Mr. Arbitrators.
Members of the tribunal, I have 2 points to make in response to the respondent's rebuttals. First, we submit that the dispute resolution clause is present in the investment agreement precisely because of the notice of arbitration that has been submitted by the claimant themselves, which can be found at page 7 of the bundle. Second, with regards to the point that 1 month, whether 1 month would constitute a reasonable period for an amicable settlement to be reached, we submit that unlike most BITs, the cooling off period here doesn't stipulate a fixed period of time. Instead, it uses the words reasonable period of time, which have to be interpreted in its purpose and objective. Ultimately, its purpose and objective would be to facilitate attempts at amicable settlement, and therefore should be read to be satisfied if genuine attempts at negotiations and consultations have been made. Thank you. Members of the tribunal, turning to our submissions on the merits of our case, we submit that the application of the HEA is discriminatory and a breach of Article 1 of the BIT. This is because Article 1, in essence, is a national treatment provision that serves the purpose of providing a level playing field between both foreign investors and local investors. To that extent, the 2009 case of Binder and Pakistan establishes 3 elements to prove a breach of a national treatment provision. First, a local company in like circumstances must be identified. Second, the foreign investor must be accorded less favorable treatment. And lastly, the less favorable treatment must be without justification. In the present case, we submit that all 3 elements will be satisfied. On the first element, it is evident that local pharmaceutical companies would serve as relevant comparators. This is because local pharmaceutical companies ultimately serve the same purpose as Pharmanex. This can be seen at page 18 of the investment agreement itself under clause 3, which states that Pharmanex leverages its resources and expertise in order to support Equiterra's healthcare sector. This serves the same purpose as local pharmaceutical companies, which provide medicines to support Equiterra's healthcare sectors too. Secondly, the regulatory regime in which the claimant and the local pharmaceutical companies operates in will be the same. They are both subject to the requirements of the HEA. This is because Clause 5 of the HEA states that it is mandatory for all stakeholders in the healthcare sector. Therefore, the first element will be satisfied here. With regards to the second element of less favorable treatment, we submit that this would also be satisfied because the claimant would be subject to stricter pricing and quota requirements than the local pharmaceutical companies. The reasons for this is twofold. First, the claimant lacks the expertise to transport medicines to the rural areas. This is because they do not have the expertise to transport medicines to regional needs, to cater to regional needs and specific niche markets in Equiterra. The local pharmaceutical companies have this expertise, which can be seen at page 4 under paragraph 12. As such, a fixed pricing and quota requirement will be more onerous on the claimant. Secondly, the claimant produces far more efficacious medicines compared to the local pharmaceutical companies, and as a result, they will inevitably incur higher costs. This can be seen at page 3 of the factual background at paragraph 9. Because of these higher costs, a fixed pricing requirement will naturally be more disadvantageous to Pharmanex in comparison to the local pharmaceutical companies.
Also, I have one question based on your submissions. The differences that you're highlighting now, how come it is not relevant to a like circumstances analysis?
Apologies, Mr. Arbitrator. Do you mind repeating the question?
Differences that you are highlighting now, how is it that they are not relevant to the like circumstances analysis which you made earlier?
Mr. Arbitrator, to prove a breach of national treatment provision, there are 3 requirements. So the first requirement is proving like circumstances as a basis of comparison. What I just addressed is with regards to the second element of less favorable treatment, and that comes after a comparator has already been identified. In other words, the local pharmaceutical companies is established to be a relevant comparator to the claimant themselves. So with regards to the second element, we submit that the claimant is effectively caught between a rock and a hard place, where they are forced to either raise the prices to reflect the higher cost or fail to meet the quotas under the HEA. Either option will result in a contravention of the HEA itself. Lastly, we submit that the less favorable treatment would be without justification because it is a result of political pressure on the government of Equiterra to avoid being replaced. And this can be seen at page 37 under paragraph 60 of Procedural Order number 2. As such, we submit that the application of the HEA is discriminatory and a breach of Article 1 of the BIT. Unless I may be of further assistance to this tribunal, this concludes my submissions.
Isn't the government simply trying to abide by the Supreme Court order?
No, Mr. Arbitrator. The HEA was enacted before the Supreme Court order itself. And our submission is that the HEA's strict pricing and quota requirements are discriminatory to the claimant.
But your allegation of discrimination, is it something which precedes the Supreme Court order, or is it a result of it?
Mr. Arbitrator, our claim that the requirements of the HEA are discriminatory precedes that of the Supreme Court order, because the requirements of the HEA were imposed before the Supreme Court decision itself. So unless I may be of further assistance to this tribunal, this concludes my submissions.
May it please the tribunal, with the tribunal's permission, I'll be taking 12 minutes for my submissions and respectfully reserve 2 minutes for rebuttals. I'll be addressing the following 2 issues. First, whether the application of the HEA is arbitrary in breach of Article 2 of the BIT. Second, whether the respondent has legal grounds to nationalize the claimant. I shall now move on to my first submission, that the respondent has undermined the claimant's legitimate expectations. Because of the superior nature of the claimant's medicines and their naturally higher cost, price-setting ability was so important to the claimant that they expressly provided for it in the IA. If I may refer you to page 18 at clause 4 of the IA, we submit that clause 4 amounts to the claimant's legitimate expectation that they would be able to set their own prices as long as it is fair. It amounts to a legitimate expectation because it is a contractual promise by the respondent that is both specific and fundamental to the claimant's investment. And it is reasonable because it is entirely congruous with the respondent's representations at the time of investing. If I may refer you to page 4 at paragraph 11. At that time, while the respondent indicated that they were going to pass the HEA, they only emphasized its overarching goals. There was nothing to suggest that the HEA would subsequently curtail their price, my apologies, members of the tribunal, their price-setting ability. And so in totality, clause 4 of the IA amounts to a legitimate expectation that the claimant can set a fair price. And what a fair price constitutes is that it must reflect the interests of both parties. So not only should it be affordable in accordance to the respondent's goal of healthcare equity, it should also give the claimant the leeway to vary their prices according to their costs. And we submit that by introducing the fixed price list under the HEA, the respondent has undermined the claimant's legitimate expectation. And there is no reasonable justification because the claimant has been entirely fair in setting their prices. As a baseline, the claimant's urban area prices are in conformity with the HEA. And this is a price level that the respondent not only finds acceptable, but it also matches the market rate despite its higher quality and higher cost. And if I may refer you to page 32 at paragraph 27, the mere 5% that the respondent is raising rural area prices is just to reflect the higher transportation costs due to a lack of healthcare infrastructure in rural areas. It is merely what is sufficient for the claimant to keep their investments going. And in any case, the additional 5% does not suddenly make the claimant's medicines unaffordable. And since the claimant has been fair in setting their prices, the respondent's subsequent introduction of the fixed price lists undermines the claimant's legitimate expectations. Moving on to my next submission, we further submit that the application, yes, Mr.
May I,
Arbitrator.
yes. You speak of legitimate expectations.
Yes,
That
Mr.
is
Arbitrator.
perhaps springing from some assurances given by the respondent.
Yes, Mr.
And
Arbitrator.
what point of time was it? Prior to the investment agreement or during or after?
Mr. Arbitrator, we submit that it was prior to the introduction of the HEA. The HEA was enacted in September 2023. This is found on page 2 at paragraph 5. And but the claimant entered into the investment agreement an entire year earlier, in September 2022. This is found on page 3 at paragraph 10. And so, yes, Mr. Arbitrator. And so that is why it undermines the claimant's previous legitimate expectations. And moving on to my submission on arbitrariness, we submit that the application of the HEA is arbitrary due to the unreasonableness of the HEA's provisions. As a matter of applicable principle, a finding of arbitrariness can be made solely by reference to the unreasonableness of the HEA's provisions. And so, even though the respondent's HEA may pursue the policy of healthcare equity, it would nevertheless be unreasonable as a measure pursuing that policy. And we submit that the HEA is unreasonable because its fixed prices and quotas are patently unreasonable. And they are so onerous to the claimant that despite the low margins that the claimant is already operating on, the HEA's fixed prices and quotas are unreasonable because they set the same price and the same quota regardless of the claimant's efficacious medicines or the cost of manufacturing them. So even if the claimant produced 90% efficacious medicines, they would be forced to sell at the same price and deliver the same quota as a 40% efficacious medicine, despite being more than twice as efficacious and that naturally costing more to make. Essentially, the provisions dictate the claimant's price and the quota that the claimant delivers at, dictating their entire business. And under this regime, it is so onerous that, if I may refer you to page 4 at paragraph 14, the claimant has repeatedly stated that just to comply with the rural area prices and quotas would undermine the entire commercial viability of their investments. This shows two things. First, it shows just how onerous the provisions of the HEA are. And second, it shows the low margins that the claimant is already operating on. The claimant understands the importance of healthcare equity to the respondent and has done their level best to keep prices affordable. And so that 5% increase in rural areas is the bare minimum to keep their investments viable. But the HEA goes further and mandates that the claimant either operate at a loss or act in breach of the HEA. So even though the respondent may argue that they have a legitimate policy in healthcare equity, it does not justify the unreasonable prices and quotas which dictate the claimant's business, forces them to operate at a loss, and even though they are already operating on low margins. In totality, the HEA's provisions amount to arbitrariness. Members of the tribunal, this concludes my submissions for the third issue. And if there are no further questions? Yes, Mr. President.
In response to an earlier question, the answer was that the respondent is arguing that, is not arguing that HEA is inconsistent with the BIT, but because it is being applied in an arbitrary and discriminatory manner, then there is a violation of BIT. I thought in your submissions also you were focusing on the application of the HEA, but then I may have late understood you saying that you were seeking to attack the HEA per se, leaving aside the application. So what exactly is the position that the respondent is taking?
Mr. Arbitrator, we submit that it is indeed the application of the HEA that is arbitrary, because it is the fixed prices and quotas which apply arbitrarily to the claimant specifically. Mr. Arbitrator, if that does that answer your question? Okay, thank you, Mr. Arbitrator. I shall now move on to my fourth submission, that the respondent does not have legal grounds to nationalize the claimant. If I may refer you to page 14 at Article 3 of the BIT, the respondent does not have legal grounds to nationalize the claimant because if it is on a discriminatory basis. And we submit that the respondent's contemplated nationalization is discriminatory because it accords differentiated treatment without reasonable justification. It is differentiated because, as submitted by my co-counsel, the blanket prices and provisions of the HEA distort the market for high-end manufacturers like the claimant by forcing them to lower their prices on par with lower efficacy medicines. And effectively, the claimant is being required to absorb the higher costs of their better medicines. And so, despite the guise of uniform treatment, it should not distract this tribunal from the effectively differentiated treatment that the claimant is being afforded. Members of the tribunal, I note that my time is up. Could I have an additional 2 minutes to wrap up my submissions? Much obliged, Mr. President. And not only is it differentiated treatment, it is also without reasonable justification because the respondent cannot point to the claimant's breach of the HEA because the application is in the first place unreasonable. Essentially, the claimant only breached the HEA because they were set up to fail. And since the claimant has acted in accordance with the IA, the respondent does not have a reasonable justification to nationalize the claimant. And we submit that since it accords the claimant differentiated treatment without reasonable justification, the respondent's nationalization is discriminatory. If there are no further questions from this tribunal, this hereby concludes my submissions. Thank you.
If the tribunal is ready, may I proceed with my submission? Much obliged. Members of the Honorable Tribunal, I am Vedant Bharadwaj, counsel for the respondent, the Government of Equiterra, in the matter present before us today. Tribunal, the claimant's case is a simple attempt to to conceal a very apparent breach and refuse its corresponding liability. It is only logical that you cannot have the cake and eat it too, and the claimant's case is riddled with many such contradictions. I will demonstrate the same over the course of the next 12 minutes through two broad submissions. Firstly, that the respondent has not breached the national treatment standard guaranteed under Article 1 of the BIT. Secondly, that the respondent has not violated the fair and equitable treatment standard guaranteed under Article 2 of the BIT. We submit that Article 1 of the BIT has not been violated for one principal reason, that the claimant has failed to discharge its burden under the national treatment standard. It is settled that violations of the national treatment standard must satisfy the same three-pronged test as mentioned by the claimants. Under this test, we submit that firstly, the claimant is not in like circumstances as the other local investors. Second, that the claimant has not been accorded treatment that is less favorable. And finally, alternatively, in any case, that the treatment is based on rational justifications. Coming to the first prong of the test, that the claimant is not a like comparator in the present case. The tribunal in Resolute Forest Products has summed up the relevant considerations to be kept in mind while making this likeness analysis. Likeness must be assessed based on the following factors: the markets in which the products operate in, the products sold themselves, the competitiveness between the products, as well as the relevant business sector in which they operate in. I invite the tribunal's attention to page 28 of the factual matrix, clarification 2 under procedural order 2. If the tribunal is with me, it reads that Pharmanex holds 25% of the market share. There are 10 other local companies that share the rest of the market share. As argued by the claimants, quite emphatically, may I add, the claimant is a massive multinational company that has provided COVID-19 vaccines at a global level. Additionally, I invite the tribunal's attention to page 4, paragraph 12 of the factual matrix. If the tribunal is with me, the last line reads, smaller local pharmaceutical companies catering to specific regional needs and niche markets within Equiterra. Clearly, the smaller local pharmaceutical companies operating in the region cannot be considered competitors to the claimant Pharmanex. Additionally, Pharmanex's medicines are of superior quality and efficacy, reflecting differences in the product that has been sold as well. Therefore, it is our submission that both these investors operate in separate business sectors. Therefore, we submit that the claimant Pharmanex is not in like circumstances as the other pharmaceutical companies in the region. Coming to the second prong of the test, we submit that the claimant has not been accorded treatment that is less favorable. We submit that the application of the Health and Equity Act is made uniformly to all pharmaceutical companies operating within the Equiterran landscape. The same can be seen in the recital of the Health and Equity Act itself. The same pricing quotas and same pricing requirements that are considered stringent to one does not account for the fact that the claimant company is the only one failing to adhere to these regulations. The same can be evidenced on page 32, Procedural Order 2, clarification number 26, which clearly states that Pharmanex, the claimant company, is the only one in breach of the regulations under the Health and Equity Act. Thirdly, we submit that in any case, the treatment accorded has based on rational justifications. The application of the HEA and its provisions for contravention are tied to a rational government policy that is uniform in its application. The goal of the HEA is a very simple one: to ensure equitable distribution of medicines across the country. Article 5 of the Bilateral Investment Treaty clearly stipulates that the claimant must adhere to the host state's laws. This has been further emphasized through Clause 2 of the Investment Agreement. The nationalization of Farmanex would provide the government with better control over the adherence to these HEA requirements. This, in turn, would further the goal of the HEA. Therefore, we submit that the treatment accorded by the respondent is based on rational policy justifications. Overall, therefore, we submit that the national treatment standard under Article 1 has not been violated by the respondent.
Counsel,
I sense-
you refer to the fact that this is the only company that has breached the HEA.
Indeed, Mr. Arbitrator.
In view of the fact that there is an analysis to be made under like circumstances, the fact that it is only one company, does it necessarily mean that they are in violation of HEA?
Mr. Arbitrator, it is clear that the HEA stipulates a uniform application of the requirements, which are 30% must be reserved, as well as the pricing requirements. It is clear that the claimant company is the only one in breach of these circumstances. Additionally, we submit that based on the claimant's quality of medicines as well as the market share that they possess, they are in fact not in like circumstances as compared to the other investors. Therefore, our broader submission is that the application of the HEA is uniform and makes no specific discrimination as against the claimant. If that satisfies the tribunal, may I move on to my second broad submission? Much obliged. Members of the tribunal, as our second broad submission before you today, we submit that the respondent has not violated the fair and equitable treatment standard guaranteed under Article 2 of the BIT. We submit the same for two main reasons. Firstly, that the application of the HEA does not undermine the legitimate expectations of the claimant. Secondly, that the application of the HEA is not arbitrary and disproportionate. Coming to our first reason, that the legitimate expectations of the claimant have not been violated. It is settled law that the standard of fair and equitable treatment that includes the stability and legitimate expectations of the foreign investor is only subject to the host state's right to regulate. As the parties entered into the investment agreement, there was agreement that the parties would collaborate on issues of healthcare equity. Further, it is specifically stated, as mentioned earlier, that the claimant would comply with all local laws. Therefore, the fair and equitable treatment standard does not preclude the host state's sovereign right of exercising its right to regulate and enforce laws in the country. Hence, we submit that the legitimate expectations of the claimant have not been violated here. On to the second reason, that the application of the HEA is not arbitrary and disproportionate. It is settled, and past tribunals have concluded similarly, that unreasonable measures are what is considered arbitrary. Therefore, in concluding whether the enactment of the HEA has been enacted in an arbitrary manner, this tribunal must assess if the HEA is established reasonably in accordance with legitimate public policy objectives. Presently, we submit that the enactment of the HEA, if successfully complied with by all pharmaceutical companies in the region, would effectively address the disparities in healthcare affordability. The fixed price mechanism under the HEA is crucial. Continuing to implement the claimant's price for essential medicines will be equivalent to allowing more than 3 million citizens with no access to affordable medication. Tribunal, this concludes our submissions on issues 2 and 3. If there are no further questions, I would pass this over to my co-counsel to take up issue 4 before the tribunal today. Thank you.
If I may begin with my submission on the fourth issue. Thank you. Over the course of the next 4 minutes, I will submit that the respondent possesses legal grounds to nationalize the claimant. As the only contention raised by the claimant in this case is regarding the discriminatory practice of Equiterra, I will consider that prong first. While my co-counsel has already covered the treatment of like and not like individuals, I will merely summarize the same. The test for discrimination involves determining whether similar cases are treated differently without reasonable justification. And in the outset, we claim that the same are not alike to other individuals in the market. Tribunals consider investments alike if they operate in the same market segment and are approximately the same size. However, these conditions are not met here. Pharmanex, as settled, is Serineland's leading pharmaceutical companies. It's renowned all across the globe for its cutting-edge medical innovations not seen in other investors or local companies. Their medicines are of a superior quality and effectiveness, and further, they hold a 25% market share in Equiterra, thereby differentiating them from other investors or local companies. As already pointed out by my co-counsel, on page 4, para 12, the other companies only engage in smaller and niche markets. And due to this, we claim that their differential treatment is indeed justified. Under Article 3, there are three other prongs. One, public purpose. Second, due diligence. And thirdly, prompt, adequate, and effective compensation. And we claim that all three are met in this case, thereby leading to a lawful direct expropriation on part of Equiterra. Moving on to my first prong regarding public purpose, the foundational premise for expropriation is that public welfare requires the taking of private property, and the same is based on a genuine public purpose. Tribunals have held that margin must be given to states to determine their own public purpose, since they are best placed to do so. And the test is merely that of reasonable nexus, whether the measure and the declared purpose have reasonable connection. And the same is met over here. The measure of nationalization is so that the respondent can directly control pricing, distribution, ensure compliance with statutory duties under the Health Equity Act, and further provide medicines to the citizens. And due to this, we claim, indeed, that the healthcare outcomes of Equiterra will improve on the basis of this nationalization. Moving to my next prong regarding due process requirements. We claim that nationalization is merely being contemplated in this case. If we look at page 37 of Procedural Order number 2 at clause 57, the tribunal is with me, you will see that nationalization has not been made public, and Pharmanex has somehow been made aware of this fact. And hence we claim that when we decide to actually nationalize the claimant company, the due process requirements will indeed be met. I see that my time is running out. Could I be granted an extension of 30 seconds more? Thank you so much. Hence, we claim that essential legal mechanisms to ensure due process requirements, reasonable advance notice, fair hearing, and an unbiased adjudicator will be provided to the claimant company in case the nationalization actually occurs. Moving on to my last prong regarding compensation, the non-payment of compensation by itself does not make an otherwise lawful expropriation invalid. If the first three prongs of public purpose, discrimination, and due process requirements are met, the inadequacy of compensation is not enough to render a lawful expropriation invalid. And the same has been held in Vesti Group versus Venezuela, where the tribunal holds that the mere offer to compensate is enough. With this, I come to the end of my submission on issue 4. Thank you, arbitrators.
May it please the tribunal, on the respondent's contentions, I have two rebuttals to make. First, on the point of discrimination, it is precisely that the claimant is the only company in breach that it demonstrates just how onerous the HEA is to just the claimant and their state-of-the-art medicines. Under the guise of fixed pricing, the respondent is essentially trying to get the claimant's medicines for cheap. Essentially, they are trying to push the healthcare costs of Equiterra onto the claimant by forcing the claimant to subsidize their higher quality medicines, showing just how discriminatory and differentiated the treatment is to the claimant. On the point of legitimate expectations, the respondent points to Clause 2 to nullify the claimant's legitimate expectations. But the respondent is precisely the party which has the power to introduce new laws. By pointing to Clause 2 to justify the subsequent introduction of the HEA, the logical extension would be that the respondent is entitled to enact any subsequent legislation to nullify the claimant's legitimate expectations. In totality, the respondent demonstrates that their position is that they are entitled to exercise their draconian powers to force the claimant to comply with the HEA and push their healthcare costs onto the claimant. And so we submit that in light of that, they should not be allowed to force draconian laws onto investors, and that the application of the HEA is both discriminatory and a breach of the FET standard. Unless I may be of further assistance to this tribunal, may it please the tribunal. Thank you.
Members of the Honorable company has failed to adhere to the regulations under the HEA and specific to the completion of quotas and fair pricing requirements in rural areas. It is quite surprising that the claimant, a huge pharmaceutical company that had the expertise to both develop and distribute COVID-19 vaccines at a global level, was not capable of taking on the same expertise to meet the logistical challenges in the area. Logistical challenges that they had prior knowledge of before entering into the agreement. Secondly, I invite the tribunal to read Article 4 completely. It is submitted that the HEA is a mere furtherance of the investment agreement as well as the bilateral treaty. As per the investment agreement, fixed quotas were already established by the respondent in the present case. Therefore, we submit that the fair pricing requirements as well as the quotas are merely in furtherance of the agreement signed. Thank you, Tribunal.
Thank you for your submissions, teams. Please remain seated as the arbitrators will now begin the scoring procedure.
the advocacy, preparation that has been put in by the two teams. We have given marks considering the case that had to be argued by both parties. Comparatively, there was a difficult side and comparatively a little bit easier side. But overall, the performance was of high standard. The preparation was reflected in the memorandums. The only difficult part about the memorandums was that we received it very late in the day. If we had received it a little bit earlier, it could have been better. But the preparation done by the Asian Law Students Association in organizing an event of this magnitude is laudable. It's a thought shared by all members of the panel. The advocacy shown by in response to the answers to the tribunal, in response to answering difficult questions, and then trying to come back to the points that are in favor of the team was commendable. The presentation styles were also greatly appreciated by the tribunal. If the questions that we asked was not clear, there was no hesitation in asking us to clarify that. And overall, we are of the view that the Moot competition was of high standard, and congratulations to both teams for an excellent performance at the final round. Thank you.
Thank you.
Thank you very much, assessors, for your valuable feedback to our participants and for your time this afternoon. I would like to thank both the parties for ensuring a very successful arbitration proceeding. The final results will be announced during the closing ceremony, and with that, we will conclude this session. Thank you.